doing virtual notaries. So as soon as they can get us back to doing face to face 100% of the time, honestly, they're going to do away with the virtual notarization. All right. Now, oops. Alright, there we go. Now, upon the faith and acknowledgement rests the title of real property, and the only security to these titles is again the fidelity, the honesty, which notaries perform their duties in requiring the appearance of parties to such instruments before them, and always refusing to execute unless the parties are actually known to them or the identity of the parties is satisfactorily provided. Equally unacceptable to the Secretary of State is a slipshod administration of the oath. The simplest form of the oath that may be lawfully administered is, do you solemnly swear that the contents of this affidavit subscribed to you are true and correct? Alternately, the following affirmation may be used for people who conscientiously decline taking an oath. Its legal equivalent. Do you solemnly, sincerely, and truly declare and affirm that the statements made by you are true and correct? Whichever form is adopted, it must be in the presence of the officer authorized to administer it, and it must be unequivocal and present act by which the affront consciously takes the oath upon themselves. Unless a lawyer, a notary, may not engage either directly or indirectly in the practice of law. Listed below are some of the activities that we are not allowed to do. So, a notary may not give advice on the law. We may not draw up any kind of legal papers, such as wills, deeds, bills of sales, mortgages, chattel mortgages, contracts, leases, offers, options, incorporation papers, releases, mechanics liens, powers of attorney, complaints, and any legal pleadings in a summary proceeding to evict a tenant or in bankruptcy, affidavits, or any papers which courts have said are legal documents. We may not ask for or get legal business to send to a lawyer or lawyers with whom we may have a business connection with. We may not divide or agree to divide our fees with any lawyers or accept any part of a lawyer's fee on any legal business. We also are not allowed to advertise in or circulate in any manner any paper or advertisement or say to anyone that we have the power or rights given to them by the notary by laws under which the notary was appointed. The notary is cautioned not to execute an acknowledgement of the execution of a will, so we cannot sign off on wills. Such acknowledgement cannot be deemed equivalent to the attestation clause that's in the will. Now, the reason they say this, guys, is truthfully, especially when you get out of the United States, the word notary means almost, in some areas, especially where they're like small villages, notaries have almost attorney-like powers. So when some people from these small areas come to this country and they see the sign notary, they think we have those same powers. Unfortunately, we do not. Now, appointment to notary, the Secretary of State may appoint and commission as many notaries as they feel best. For appointment, notary public shall have a term for 4 years. The application for the appointment as notary shall be in form set forth in manners as the Secretary of State shall prescribe. Each person appointed as notary must at the time of their appointment be a citizen of the U.S. and either a resident of the state of New York or have an office or a place of business in New York State. A notary who is a resident of the state of New York and moves out of the state, but maintains a place of business or an office in New York, does not vacate their office as a notary. A notary public who is a non-resident and who ceases to have an office or place of business in the state will then vacate their office as a notary public. A notary public who is a resident of New York and moves out of state, who does not retain the office or place of business, again shall vacate their office. So that's very important. If I live and work in the state, I can be a notary. If I move out of the state but still have my office in New York, that's fine. I can still be a notary. It's called a non-resident resident, as crazy as that sounds. But if I move out of New York and also take my business with me, then I must vacate the office. All right? That's very important. All right? Now, a non-resident who accepts the office of notary in the state, thereby appointed by the Secretary of State as a person whose process can be served on or his behalf, before issuing to any applicant a commissioned notary, unless they be an attorney or a counsel of law admitted to practice in the state and the court clerk of the Unified Court System, or has been appointed to such position after taking the civil service exam, series of titles, the Secretary of State shall satisfy themselves that the applicant is of good moral character, has the equivalent of a common school education, see, we don't need a doctorate or a PhD, and is familiar with the duties and responsibilities of the notary public. Provided, however, that where a notary public applies before the expiration of their term for reappointment with the clerk, or where a person whose term as a notary shall expire reapplies within 6 months, their reappointment will be considered. However, if you wait past 6 months, you have to go back and take the exam all over again. All right? Now, if the person failed or was unable to apply by reason of their induction or enlistment in the armed forces of the U.S., such requirements may also be waived by the Secretary of State, provided such application for reappointment is made within a period of 1 year after a military discharge of the applicant under conditions other than dishonorable. In any case, the appointment or reappointment of the applicant is at the discretion of the Secretary of State. Now, the Secretary of State may also suspend or remove from office for misconduct any notary appointed by them, but no removal shall be made unless the person who is sought to be removed has been served with a copy of the charges against them and have had an opportunity to be heard. So again, they can't just, get rid of you. They have to give you an opportunity to be heard. Now, no person shall be appointed notary under this article who's been convicted in New York State or any other state of the following felonies: illegally using, carrying, or possessing a pistol or other dangerous weapon, making or possessing burglar's instruments, buying or receiving criminally possessing stolen property, unlawful entry of a building, aiding an escapee from prison, unlawfully possessing or distributing habit-forming narcotics, violating vagrancy or prostitution, and has not received a executive pardon or a certificate of relief from disabilities from good conduct pursuant to Article 23 of the Correction Law. Now, a person regularly admitted to practice an attorney and a counselor in the courts of the record of the state, whose office for the practice of law is within the state, may be appointed a notary public and retain his office as such notary public, although he resides or moves to another adjoining state. For the purpose of this, the following section of this article, this person shall be deemed a resident of the county where they maintain such an office. Now, procedures for appointments. fees, and commissions. Applicant for a notary shall submit to the Secretary of State with their application the oath of office, duly executed before a person authorized to administer an oath, together with their signature. Upon having satisfied the competency and good character of the applicant for appointment as a notary, the Secretary of State shall issue a commission to such person, and the official signature will be filed with the oath of office, and will be filed with such application. The Secretary shall receive a non-refundable application fee of $60 from the applicant for the appointment. This fee shall be submitted with the application. No other fees are required. A notary public ID card indicating their name, address, county, and commission term will be sent to the appointee. The commission, duly dated, a certified copy of the original oath of office and official signature, and $20 from the $60 fee will be sent to the county clerk's office so that they can file your signature. The county clerk shall make proper index of the commission and the official signature sent by the Secretary of State. Now, like I said, when we get reappointed, it goes backwards. Applicants for reappointments of Notary Public Commission shall submit to the county clerk their application, oath of office, duly executed before a person authorized to administer it. Again, we have to have it notarized again. Upon being satisfied of the completeness of the application, the county clerk shall issue a commission to such person. The clerk shall receive again a non-refundable fee of $60 from each applicant for reappointment. No other fees are needed. The commission, duly dated, and a certified copy of the application and $40 from the $60 fee will then be sent up to the Secretary of State for their recording. The Secretary of State shall make proper records of the commission transmitted by the county clerk, and except for changes made on applications for reappointment, the Secretary of State shall receive a non-refundable fee of $10 for a name or address change by the notary. Now, the Secretary of State may issue a duplicate ID card to the notary for one lost, destroyed, or damaged. Again, the fee for that is $10. Now, certificates of official character, some notary. Now, this happens, guys, when you're working sometimes on a little higher up cases. For instance, something in the Supreme Court or something of that nature, where because of the level of the case, your signature as a notary may need to be certified. So once in a while this may come to pass, especially as a notary, you're working in a legal capacity for a lawyer's office or something like that. Now, Secretary of State or the clerk, the county clerk, in which you're commissioned, the notary public is filed, may certify to the official character of such notary, and any notary may file their autograph and a certificate of official character in the office of that county clerk or any county clerk throughout the state. Now, they will have to register, and thereby such county clerk may certify as to the official character of said notary. The Secretary of State shall collect for each certificate of official character issued by them a sum of $10. The clerk will register of the county in whom the certificate has been filed and shall collect the same, a $10 fee, for each certificate of official character. With seal attached, any county clerk, the sum of $5 will be collected by them. Now, certification of notarial signatures. County clerk of the county where the notary has qualified for or has filed their autograph and a certificate of official character shall, when requested and upon a fee of $3 affixed to any certificate or proof of acknowledgement or oath signed by such notary throughout the state of New York, a certificate under hand and seal stating that the commission or certificate of their official character with their autograph is filed at that office, and that he was at the time taking such proof acknowledgement or authorized to do the same, that he is well acquainted with the handwriting of such notary public, or has compared the signature with the official signature on file. Now, an instrument with such certificate of authentication of the county clerk is then affixed thereto shall be entitled to be read in evidence or to be recorded in any county of the state. Again, like I said, guys, they do this sometimes on a higher level, like Supreme Court cases and things like that. Now, Executive Law 14. No person who has been removed from office as a Commissioner of Deeds of New York or hereby provided shall be eligible again to be appointed as such commissioner, nor shall they be eligible to be appointed to the office of Notary Public any person who has been removed from office as the aforesaid, who shall, after acknowledging such removal, sign or execute any instrument as a Commissioner of Deeds or Notary Public, you will be deemed guilty of a misdemeanor. So that's the thing, guys. Truthfully, if you lose your license, that's it. They will not grant you a new one. It's a one-shot deal. All right. Now, election law. Commissioner of Elections or Inspector of Elections is eligible to be a notary. Public officer law. No person is eligible for the office of notary if they have been convicted as a violation of the Selective Draft Act. So if you're a draft dodger, you're not applicable to be a notary. County law. Each county clerk's office shall designate from among the members of their staff at least one notary public to be available to notarize documents for the public in their office during normal business hours free of charge. So again, if you want to work at the clerk's office, it helps to be a notary. Members of legislature. Members of legislature shall be appointed an office of civil duty. Now, under New York state law, their acceptance, therefore, shall vacate his or her seat as legislator, provided they can still be reappointed. A member of legislation may be appointed as a notary public. Now, notary public disqualifications. Though a person may be eligible to hold the office of notary, the person may be disqualified to act in certain cases by reasons of having an interest in the case. To state the rule broadly, if the notary is party, directly or indirectly, or interested in the transaction, they are not capable of acting in the case. For example, if my mother is buying a house, I can notarize all the documents she needs, no problem. However, if me and my mother are buying the house together, I cannot notarize any of the documents. I can't even notarize her documents because I have an interest now in that property. Okay, so that's very important. Now, notary, beneficially interested in the conveyance by way of being secured thereby, is not competent to take the acknowledgement. Again, if I am involved in the transaction, I cannot notarize. All right. Now, executive law. Signature and seal of the county clerk. Now, upon certificate of official character, notary public, or the signature of the county clerk, upon certificate of authentication of the signature and acts of the notary public or commissioner, it may be a facsimile, printed, stamped, photographed, or even engraved on. Now, powers and duties. In general, notaries who are attorneys at law. Every notary duly qualified is hereby authorized and empowered within and throughout the state to administer oaths, affirmations, take affidavits and depositions, and to receive and certify acknowledgments or proofs of deeds, mortgages, and powers of attorney, and other instruments in writing, to demand acceptance of payments of foreign or inland bills of exchange, promissory notes, obligations in writing, and protest the same for non-acceptance or non-payment as the case may be required, and for even use in other jurisdictions, to exercise such other powers and duties as the law of nations according to commercial usage, or by the laws of other government or counties. Such powers shall be set forth in the name of such jurisdiction. A notary, who is an attorney at law, regularly admitted to practice in the state, in his discretion, may administer an oath or affirmation, or take the affidavit acknowledgment of their client in respect to any matter, claim, action, or proceeding. For any, however, misconduct by a notary in the performance of any of their powers, such notary shall be liable to the parties injured for all damages sustained by them. A notary public shall not directly or indirectly demand or receive a protest for the non-payment of any note or any non-acceptance or non-payment of any bill of exchange, check, or draft, in giving the requisite notice and certificates of such protest, including the seal, if affixed, any greater fee or reward greater than 75 cents per protest, plus 10 cents each additional, not to exceed 5 total. Alright, so again, that's important. Now, notary publics or commissioners in deeds. Any person who holds themselves out to the public as being certified or entitled to act as a notary, public or commissioner of deeds, or who assumes, uses, or advertises the title of notary or commissioner of